Good afternoon. I'm Angelica Spanos, and this is the Law and Crime Report, diving into true crime and all legal stories making headlines today. Let's get started. A judge in Wisconsin ruled that Kyle Rittenhouse will stand trial on all 6 counts related to the shooting deaths of 2 men and injuring another person during the protests in Kenosha back in August. Rittenhouse told police that he was attacked while he was guarding a business during BLM protests and the civil unrest that broke out there after a police shooting of a black man. Rittenhouse said that he fired in self-defense. While he's charged with homicide and attempted homicide, he was free from jail last month after posting $2 million bond. His defense asked the court to dismiss 2 of the 6 counts against him. Let's listen.
The government talked about, well, this is for hunting and things like this. There are 2 other prohibitions that are set forth in the statute. Wisconsin Stat 29.304 only applies to people who are under the age of 16. Consequently, it does not apply to Kyle. The criminal complaint sets forth my client's birth date. He was 17 on August 25th, 2020. As to 29593, that has to do with hunter certification. If an individual is out hunting, and that's what Mr. Binger was hanging his hat on. There is no allegation anywhere that my client was hunting on August 25th, 2020. So it does not meet the requirements of statute 948.63. The statute is clear on its face, must be construed strictly to my client's benefit. Additionally, what the government is trying to seek is an impingement of my client's Second Amendment rights, which is not covered by this statute. It's very specific regarding when it's a misdemeanor, what it applies to, and there's basically 3 prohibitions, none of which are met. The statutory history, which is included in the brief, makes that clear. Count 6 should be dismissed.
The defense argued that a misdemeanor count of possession of a dangerous weapon by a person under 18 isn't supported by the law. Let's listen to the prosecution's response.
Your Honor, counsel is correct that this court has already heard these arguments and has already rejected an oral motion to dismiss count 6. So we're rehashing ground that we've already covered in this case and has already been decided by Your Honor. First of all, I would note that I don't think there's going to be any dispute that everything that happened on the night of August 25th is transactionally related. So the defense can file a motion to dismiss a count in the complaint today. But if the defendant is bound over for trial, the state will simply file an information containing all transactionally related counts, and we'll let a jury decide. So this is sort of form over substance here, because if the defendant is bound over, we're going to file an information with a charge that the defendant possessed a dangerous weapon as a minor. And so this is sort of moot at that point. However, there is a substantial legal basis for the count 6. And that is, we don't allow teenagers to run around with guns. It's really that simple. The statute is clear. 948.60 says any person under 18 who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor, period. There's no dispute in this case that Kyle Rittenhouse armed himself with an AR-15 on August 25th, 2020 at the age of 17 years old. That's it. It's that simple. Now, if the defense wants to hide behind hunter safety regulations to try and excuse that behavior, then I'll simply quote back what Attorney Richards just said, which is the defendant wasn't hunting. It wasn't hunting season. This wasn't a kid who went up north with his dad and a shotgun and went hunting for deer like last week during hunting season here in Wisconsin. This was a situation in which a teenager went running around the streets of Kenosha after curfew with a very dangerous weapon. And this is exactly why we have this law, because a teenager in this case killed 2 people and shot a 3rd, because teenagers shouldn't be allowed to run around with dangerous weapons because bad things happen.
When I look at that statute, It talks about, it defines what a dangerous weapon is: any firearm, loaded or unloaded, any electronic or electric weapon as defined further in the statute 941.295 sub 1C sub A. And then it goes on to list other additional items which are defined as being weapons. But specifically dangerous weapon, which is quoted, means any firearm loaded or unloaded. Clearly in the case at bar here, it is a loaded firearm. It was possessed by someone 17 years old, which is it's uncontroverted that this defendant was 17 years old and had not attained the age of 18 on the night in question, August 25th of 2020. And if you look at the plain language here, and I understand reading the whole statute, which I have done as well, but I do see here that I think it's a bit of a red herring to discuss barrel length or to discuss whether that clouds the issue. And I believe the issue at this point, for purposes of whether or not to grant the motion or not grant the motion and move this matter forward to preliminary hearing, for purposes here, I'm going to deny that motion.
All right, so that was the judge rejecting that motion. We also heard the prosecution's response there. Joining me now today to break all of this down, we have Gene Rossi, law and crime legal analyst, as well as Leslie Ricard Chambers, former prosecutor. Thank you both for joining us today. Let's talk about this. Gene, what do you think about the judge denying this this misdemeanor motion here?
I think it was a proper ruling. I got to give credit to the defense attorney. He's being creative. He's making good faith arguments. And when you try to dismiss charges before preliminary hearing or before trial, based on just the allegations themselves, it's very, very hard for a court to get rid of indictments. I had a hearing Wednesday in Albemarle County, Virginia, and it's hard. It was a different issue, but it's difficult. Now, regarding this specific statute, Judge Keating hit the nail on the head. If you just read the statute itself, even an unloaded gun can be a dangerous weapon. This, of course, was loaded, and it wasn't a BB gun. It's an AR-15, which is one of the most powerful weapons on the planet. And there's no dispute that Mr. Rittenhouse was 17 years old. So this was a no-brainer to me. But I give credit to the defense attorney for fighting a good fight and trying to get those charges dismissed.
All right. And Leslie, coming out to you, what are your thoughts on the judge's ruling there?
I completely agree with Gene here. And what we've got to remember is that we're talking about whether or not there are sufficient grounds to move forward with a preliminary exam. In other words, did the officers have probable cause to make an arrest for the charges for which the defendant has been indicted on? And it appears as if the judge is sort of saying, yes, I believe that a preliminary exam is going to be proper because, as Gene said, if you just look at the basic language of the statute, the circumstances here meet all of the elements. He was under the age of 18. He definitely possessed a dangerous weapon, a military-styled weapon at that. And so I agree that the judge properly and accurately made the right ruling here.
Okay, Leslie, Gene, thank you. Let's move on because we want to get to the next count that the defense also tried to dismiss. This was a felony count against Rittenhouse for recklessly endangering the public safety by using a dangerous weapon. Now, this count relates to Rittenhouse allegedly brandishing the weapon around a reporter who was at the scene during those protests and during the civil unrest that was happening at that time. Let's listen.
There's nothing in the criminal complaint that says Mr. McGinnis was in the line of fire. There's nothing in the criminal complaint that says he feared for his safety. There's nothing in the complaint that my client recklessly, intentionally, or otherwise pointed the gun at Mr. McGinnis. I believe based upon that, the count 2, as it applies to Mr. McGinnis, should be dismissed.
All right, so let's now listen to the prosecution's response there to his defense.
The complaint does explicitly say that Mr. Guinness was in the line of fire. I'll read the relevant portion, which I believe is at the top of page 4 of the complaint. I'll actually begin at the bottom of page 3 and put it in context. I'm going to start by reading the final paragraph on the bottom of page 3. It begins, McGinnis described, and it's a paragraph that continues on to the top of the next page. The paragraph states, McGinnis described the point where the defendant had reached the car. McGinnis described that the defendant had the gun in a low, ready position, meaning that he had the gun raised but pointed downward. The butt of the gun would have been at an angle downwards from the shoulder. McGinnis stated that the defendant brought the gun up. McGinnis stated that he stepped back and he thinks the defendant, this is at the top of page 4, he thinks the defendant fired 3 rounds in rapid succession. McGinnis said that when the first round went off, he thought it hit the pavement. McGinnis felt something on his leg, and his first thought was wondering whether he had gotten shot. McGinnis was behind and slightly to the right of Rosenbaum in the line of fire when the defendant shot. That ends that paragraph. As the paragraph indicates, which is in the complaint, Mr. McGinnis was in the line of fire, felt that he had been shot, and was in close proximity to someone who was shot and killed by the defendant. I believe that that satisfies the statutory requirements, and the motion to dismiss count 2 should be denied.
All right, so that was about the felony count against Rittenhouse, and that has to do with this dangerous weapon. And Gene, you mentioned this before. This wasn't just a knife or a handgun or something. This was an AR-15. So how do you think the fact that it was that type of gun plays into this charge and the judge possibly denying that motion for the defense?
I think it played a huge part, Angelica, because you know, a pen could be a dangerous weapon if you use it a certain way. In prison, they'd make shanks, and shanks are considered dangerous weapons. They're objects that are made to either puncture or wound somebody. So I think it's not a big leap of faith to go from a shank to an AR-15 to consider it a dangerous weapon. But what's interesting is the victim, the alleged victim, against whom this charge is made, he felt something hit his body after a shot was heard, and he thought he himself had been hit by a bullet. So I think it definitely satisfies use of a deadly weapon that threatens public safety.
All right, Gene and Leslie, what are your thoughts on that? Because I know that, you know, as Gene just said, a dangerous weapon could be a pen. So obviously we're not dealing with a pen here. Did the judge make the right call on this? All right, it looks like we are having trouble finding Leslie there. Gene, I'm coming back to you.
That's okay.
Let's talk a little bit about this in general, because we know this had a video component of it. There is a video and you see Rittenhouse under attack. He gets shot at himself. He gets kicked. He gets hit in the head with a skateboard. So when you have his defense saying that this was all in self-defense, do you think that that stands looking at that video?
Let me tell you this. I'm now a defense attorney. I was a prosecutor for 27 years with the Department of Justice. And I always tried to figure out what the defense was going to argue. And I tried to be as objective as possible. And I'm trying to be objective here. There's a lot of publicity, a lot of emotion involved with this case. But there is a good faith argument that they're making that he was acting in self-defense. Now, those other 2 charges, the possession under 18 and endangering the public safety, those are tough. But if you look at the video, he was crazy to go to that rally or that protest. But there were individuals that were coming towards him. Now, the prosecutor's argument is he stirred the pot by going into the crowd and creating the havoc. He created the havoc that caused them to come towards him. But the video does show that people are allegedly trying to attack him. If I'm a defense attorney, that's what I would argue. So that video does provide a good faith argument to the defense. Whether a jury accepts that because the defendant created his havoc, that's a different matter.
Right. It'll be interesting to see that because they're going to probably use that video in the trial. Again, another example of how everyone has a recording device on them, and these sort of videos that surface around these violent incidents always are very important. All right, Jean, thank you so much. We're going to take a quick break right now on Law and Crime. When we come back, we'll continue this conversation on Kyle Rittenhouse. Stay with us here after this. And welcome back to the Law and Crime Report. I'm Angelica Spanos. We're going to continue discussing Kyle Rittenhouse here right now. A judge ruled against the defense's request to dismiss any charges against him. He is being ordered to stand trial. Let's take a listen.
Well, I've read the complaint as well, obviously, and again, a number of times. And the issue comes down to what's a reasonable inference or not. In this case, when you discharge, or it's alleged that this defendant discharged a firearm in a crowded urban environment, one could argue that's inherently dangerous nonetheless. Issues whether or not that was in self-defense or otherwise are for trial, obviously. With respect to the issue of whether or not, in this case, Mr. McGinnis was endangered or recklessly endangered, that's, again, an issue for trial. When you have in the complaint sets forth reasonable inferences that this defendant discharged a weapon that Mr. McGinnis thought it hit the pavement. Okay, well, as most people know, when a bullet ricochets, you never know, for the most part, where that bullet's going to ricochet to, or what trajectory the bullet takes. I don't know, as I sit here today, whether or not what Mr. McGinnis indicated, according to the complaint, they're feeling something on his leg. I don't know what that was. That's a trial issue, I believe. And again, a reasonable inference here that Mr. McGinnis is set forth, it says in the line of fire. That is definitely probably a trial issue in terms of whether or not Mr. McGinnis was had his safety endangered recklessly by this defendant with respect to the alleged discharge of the weapon. So for all of those reasons, again, there are some conclusory statements on both sides here. Those are issues for trial. This court is going to deny your motion for count 2 as well, Mr. Richards, for the reasons I've just stated. I do find the state has demonstrated probable cause that in this case, felonies were committed relating to the counts in the complaint. I bind over as such that probable cause further exists that this defendant committed those felonies, including count 1 and the other felonies here in this file or in the criminal complaint. Therefore, as I do find that probable cause exists that the defendant committed those felonies, the defendant in this case is bound over before the Kenosha County Circuit Court.
All right, so we know that Kyle Rittenhouse is going to go to trial here on all 6 of these counts. Leslie Ricard Chambers with us today, former prosecutor. From your point of view as a former prosecutor here, what do you think, what can we expect from this trial, from the prosecution stand of this, and what do you make of these charges being dismissed? Sorry, not the charges, the motions.
Well, I think that any defense attorney who pursues requesting the court to dismiss a case prior to a probable cause hearing almost always has very little chance of succeeding at those motions. It is a probable cause hearing. And again, as I mentioned at the beginning of the broadcast, we're talking about whether or not the police had enough information or enough evidence to arrest the person for the offense for which he has been arrested for. And so I believe that the court concluded correctly that number one, that probable cause is definitely found, but in terms of the actual facts that prove the elements of the charges for which he's been arrested for and billed on or indicted on, those are issues for the trier of fact to settle, right? So, while the victim was able to, or the witnesses as well, were able to provide police officers with enough information to get from, I guess that what I would consider to be that from point A to point B in this process. At the end of the criminal justice process, if you will, it'll be up to a jury or the judge, if he is the trier of fact, to determine whether or not he is in fact guilty of this crime or these crimes.
And when you think about the self-defense here by his attorney, what do you think? Do you think that's a strong argument there, Leslie?
I think that it is potentially a challenge, mostly because if we all recall here, this defendant is not a resident of Kenosha. His mother drove him to the area for the purposes of being in the midst of the protests. And while he was there, what we've learned is that he ended up possessing somehow or obtaining this assault style weapon. And so I find that it's going to be really difficult here to overcome the idea that based on common sense, that he didn't go there looking for trouble. And even though one may argue that trouble ended up finding him, it's really hard to accept the fact that yes, while trouble found him, it's presumed reasonably that he went there looking for it, not just because he went to diffuse or fight against the violent protests, but he went there with an assault rifle. I mean, and I find it difficult. I would find it difficult for reasonable people to believe that he went there for with self-defense motivations.
All right, Leslie, thank you so much. We're going to switch gears right now, get to another story. A former Arizona elected official is sentenced to 74 months in federal prison for an adoption scheme. Prosecutors called Paul Peterson's, quote, baby selling enterprise a get-rich-quick scheme hidden behind a veneer of humanitarian operation. Peterson was convicted of smuggling pregnant women from the Marshall Islands to 3 different states as part of an adoption scheme. He pled guilty to the charges of human smuggling, communication fraud, and other charges. On top of the federal charges, he could face additional time on state charges. This is a very complicated, interesting story here. He is scheduled for sentencing in Utah and Arizona in January. He faces up to 15 years in Utah and a 16.5 in Arizona. Again, this is all on top of the federal charges. And he has 14 days to appeal this most recent sentence. So, Gene, Rossi, out to you. Do you think that he'll file an appeal here? Is that likely that he could get anything from that?
When you plead guilty, especially with federal charges, he probably has a very fulsome written plea agreement that the U.S. Attorney's Office in Arizona wrote. And I got to tell you, he probably waived his right to appeal. He probably waived his right to appeal the sentence. And the only thing you can appeal when you plead guilty at the federal level, at least my experience, is if the judge did something that was so blatantly unconstitutional. You know, for example, sentencing an African-American man to a higher range because he's black or because someone's Muslim. That would be appealable. But if he's trying to appeal his conviction, I think he's wasting his money.
All right. And this story is kind of crazy if you think about it. I mean, he was running this scheme. There was a lot of people involved here. Pretty intricate thing to really operate. What are your thoughts on this?
I love fraud cases, and I love fraud cases by public officials because fraud cases always take a level of sophistication and deviousness and evil intent. It's not like a heat of passion. You know, somebody takes somebody's life in the heat of passion. Fraud cases have a lot of premeditation and sophistication. And This is an incredibly egregious crime. And I got to tell you, he's lucky he only got 6 years. What was he doing? He was trying to persuade and did persuade women who were pregnant in the Marshall Islands to file false immigration papers to get them into the United States. Then he was having the women give birth. And then he was fraudulently milking the state government for daycare services and healthcare services. And he padded his pocket all the while by this scheme, this adoption scheme. And I got to tell you, any public official, and I guess he was a county assessor, public officials, if they violate their position of trust, they need to pay.
All right, Gene Rossi, I like that. Thank you so much. We're going to take a break right now on Law and Crime. When we come back, plenty more topics to discuss. Stay with us after this.
If I was to be able to go back in time, I would definitely have stepped up and changed a whole bunch of different scenarios. Just speaking up, one of them, not being afraid to say this doesn't seem right, and I would have been able to change the whole situation, and that's one of the reasons I felt shameful, because I didn't step up when it was time to step up, even though that's what I was taught to be. So that's what I would change if I could go back.
And welcome back. That was Brandon Bernard, an inmate on federal death row who's scheduled to be executed on December 10th. But now, after being convicted of murders and sentenced to death, many are speaking out for him and saying that he should not be executed. The prosecutor who fought for his death row sentence now says that the death penalty is too harsh. Joining him is Kim Kardashian West and some jurors who voted for his conviction. They're all calling for clemency. Now, Bernard was involved in the murders of 2 youth ministers, Todd and Stacy Bagley. The man responsible for shooting them was a fellow gang member of Bernard's. He was already executed in September. So now the question is this correct? Should this be reversed? All these people coming out and fighting against this. I want to talk to my guests right now. Gene Rossi, Law and Crime legal analyst. What do you think about this and the kind of backtracking here on this sentence?
Well, the jurors and the prosecutor, they must have had an epiphany. And I got to say right now, I have a lot of troubles and reservations about the death penalty. 25 years ago, I had a different attitude. So they're going through epiphanies. They're realizing that this defendant did not have that severe role that was worthy of the death penalty. But here's the problem. The only remedy, as I see it, is to go to the governor of the state and get a commutation of that sentence, to drop it from death penalty to life. That's the only remedy I see. It's not a pardon, but it would be a commutation from life or death to life. And to me, that seems like the only remedy. But here's the other problem. If we allow jurors to have second thoughts about decisions on guilt and the punishment, and that's what's going on here, then a lot of the convictions over the years at the state and federal level would be vacated. And the case law on jurors who have second thoughts about their decision, the courts do not reverse convictions because a juror 10 years or 5 years after a conviction changes their mind. There won't be any finality.
Oh, wow. Okay, that's interesting. So, Leslie, these jurors, as Gene's saying, going back on their conviction, if they were to allow this, say, for Bernard, does that set a bad example for others' trials going forward and other convictions that then maybe people will say, oh, well, I want to change my mind about this This was only a few years ago. Let's move forward with that process.
I have an anecdote. I can't hear her.
Once you have those, then the prosecution then goes back and they look at the different convictions that probably may have a question, right? And clearly the prosecutor or the prosecutor's office, in some degree, has some questions here about the convictions of this particular inmate, and so. I don't know that we necessarily just ought to completely disregard the concerns of the trier of fact, but we should, in fact, be looking at cases where new evidence has manifested itself, and really giving justice an opportunity to really happen here. I mean, we've in this country, we have convicted and sent enough innocent people to death row. We have convicted too many people to long-term prison sentences, and so I do believe that even though it's clear that the person participated in the crime at least as a principal or an accomplice, just because that person participated in that fashion doesn't mean that the new evidence should be completely disregarded. And so I definitely understand the need to go back and look at this new evidence that's presented, and I think that everyone involved should really give it a good chance, and really give it high consideration.
All right, Leslie, Jean, thank you both. We're going to switch gears right now. Another story. Democratic lawmakers want to amend a section of the 13th Amendment. The 13th Amendment abolished slavery, but they're looking at another part of it about forced prison labor. In a joint resolution, it would remove the amendment's punishment clause, which has language that accepted convicted prisoners from the ban on slavery and involuntary servitude. Work programs for prisoners would continue on a voluntary basis, and that clause from the 13th Amendment would be struck out and end forced labor among prisoners. Now, my question here is, this is obviously a very bold motion, perhaps. Is it likely that these efforts will succeed, Jean? What do you think?
Whenever you amend the Constitution, just look at the Equal Rights Amendment. It is a very tough thing to do. Prohibition was easy. People wanted to drink alcohol. But for other amendments, it was very difficult. And even in 1865, getting the anti-slavery amendments passed, that was a tough road to hoe. There's a great movie about this and all the challenges Lincoln had. But the problem with this resolution and this proposed change in the Constitution is the 8th Amendment says you can't have cruel and unusual punishment. But the 13th Amendment basically provides an exception for that. You can have involuntary servitude essentially inside a prison. However, the federal government can pass statutes that say at the federal level, and I don't know if they could get to the state level, they can say that in prisons, at the federal level at least, prisoners cannot be involuntarily required to engage in manual labor. But to get the Constitution amended, that's not going to happen.
All right. Thank you, Jean Rossi. So we will be keeping our eye on that story. We got to take a break right now on Law and Crime. When we come back, more topics and headlines making news today. Stay with us after this.
A Florida mother run over by teens while defending her son has succumbed to her injuries. The Polk County Sheriff's Office says Suzette Penton died 2 weeks after being hit with a van. Penton was reportedly helping her son because his ex-girlfriend and her friends came over to beat him up. The sheriff says the teens retreated to their van when Penton went outside. She was trying to take photographs of the van as it fled.
Stand still. Elijah stands still, runs over her, completely over her. She has tire tracks on her body where he runs totally over her. As we speak today, Detective Fulcher from our homicide team is on his way to the South County Jail where he's still locked up to charge him with murder.
18-year-old Elijah Stansell is facing charges of first-degree murder. The 3 teens involved, ages 14 to 16, will be charged as adults.
All right, that was our very own Law and Crime Daily Report on this tragic story out of Florida. So Florida police have charged 18-year-old with first-degree murder. This charge was upgraded after the teen was accused of running over the victim, a local librarian named Suzette Penton. Elijah Stansell, that is the oldest of the 4 teenagers involved, and he was the one driving the car, according to police. So he is the one that is charged with first-degree murder. This is a very tragic, crazy story here. Leslie, what are your thoughts on this?
You know, this is absolutely sad. The mother clearly had every intention of preserving and capturing as much evidence as she could to turn over to police. And because of that, that ended up being the result or the reasons for why this monstrous 18-year-old decided to run over her and end her life. These teens clearly went to her home with the objective of brutalizing her son over some relationship issues with a teenage girlfriend, I believe. And you know, I think that the right call for law enforcement was to definitely charge him with first-degree murder. And I'm not sure if an indictment has officially followed, but if it has, I think that that's the right call as well.
And we know that the other teens involved are going to be charged as adults, even though I believe, you know, one of them was 14 years old or so, I believe. So, Jean, you know, knowing that these kids really are being charged with these severe charges, you know, including the first-degree murder charge, these are children. How is this going to play out when this does go to the courts?
Angelica, you hit the nail on the head. When you charge teenagers, even someone who's 18, but when you charge somebody who's under 18, I always look at what is the jury going to see when you present those charges in a courtroom. And you're going to see young people sitting at that defense table looking absolutely pathetic. Now, on the day of the crime, they may have had malintent and evil motive. But during the trial, they are going to look pathetic. They are going to look humble. They are going to look frail. And the defense attorney is going to use that, him or her, to their advantage. And what I predict, if this does go to trial, a jury's not going to convict them of first degree, maybe this Stansell guy, but the others, they're not going to get the first degree or murder charges. I think at best, they're probably going to get manslaughter or aiding and abetting in manslaughter because they're teenagers, they're kids. I have 3 kids. Their brains don't develop till they're 28, even then. So when they're teenagers, their thought process is just not the same. That's why we have laws that set limits on when you can charge somebody as an adult.
All right, Jean, thank you. Leslie, thank you. We have one more story we want to get to today. After a typical night out in Dallas, a couple, Marshall Boyd and his girlfriend, were shot. This happened in November. A black SUV pulled up next to them, shot Boyd in the back of the head, and drove off. He was hanging on for his life. He survived by just a matter of inches. Law and Crime's Anjanette Levy has more on this story.
When I got shot, it was like I was floating in the deepest, darkest water.
Marshall Boyd is home from the hospital after surviving a hail of bullets fired at his car.
When this gentleman pulled back up next to us, he had his window down, and that's when he started firing. And the first, I don't know, first shot hit me in the head, so I don't know. I can't tell you much after that.
The bullets hit Boyd in the back, head and hand. Stephanie Thomas ducked and fortunately wasn't hit.
He kept telling me, call my kids, tell them I love them, and I love you, and call my mom. And I'm like, you're going to tell your kids you love them. Don't talk like that. Just stay with me. Stay with me.
Boyd and Thomas shared these photos of the car. Dallas police say 31-year-old Jeremy Harris fired 16 times. He's also charged with killing the father of his ex-girlfriend and 3 people in Dallas that he didn't know. Police say 2 other people survived being shot.
In my opinion, based on what I've seen so far, I believe that this is the definition of a serial killer. It's random. There is no known association between victims.
Police had released surveillance video and a screenshot of a black Chevy Tahoe used in the shootings. Boyd says Harris was driving a black SUV when he was shot. He's grateful to be alive.
When I found out that nobody had survived an encounter with this guy yet, I was even more emotional about it all. It's been an emotional thing.
All right, so a very emotional story there. Luckily, well, not luckily, but this incident that was just described, this was just many for the alleged shooter here, Jeremy Harris. So Harris was dubbed a serial killer. He allegedly killed 4 other people other than injuring Marshall Boyd. And this led to his arrest here. So, you know, this is a tragic incident, but it led to hopefully some sort of justice in the future. Leslie, what do you make of this?
Well, I am just glad that that victim was able to survive. I am glad that his mate who was with him was not injured at all. And thank God that someone is alive today to tell the story and identify, to give some description of the vehicle or the person that that committed this. Because as you know, as you probably know, serial killers, they kill and they hunt and they commit crimes for a long time, sometimes without even being caught. And in this case, thank goodness, they were able to survive and give some type of statement to police that led to the arrest of this defendant.
Absolutely. And, you know, when you have an alleged serial killer who's killing multiple people and going through sort of this small community as it's described, is that really a serial killer by definition?
I believe so. I think that I think you can define it as a serial killer. I mean, because there's really no specific rhyme or reason that serial killers have for their targets. And so it's the repetition, is the lack of rationalism, I guess, no nexus to the victim itself, other than the fact that they're a human being and they want to kill for whatever reason. And so, you know, I think that that's probably not necessarily an element that the state needs in order to prove the murder, but I do think that it gives them that it gives a description to the jury, at least, that this is a person that was pursuing the killing of multiple people for no reason at all.
All right, Leslie, Ricard, Chambers, thanks for joining us today. Gene Rossi, thank you as well. It was a great afternoon here. We have plenty more of our regular scheduled programming coming up after this. I'm Angelica Spanos. Stay with us here on Law and Crime.